here once again. All right, now we're back in action. And again, just to emphasize, from Transaction Center, you go to Risk Management, and then Legal Tools is where a lot of the content is located. Click here, then it has the different titles, and this is the topic we're going to be talking about today, which is the California Consumer Privacy Act. Okay, so let's here. Okay, there we are. Awesome. Well, Happy New Year to all of you. Thank you so much for being here at class today. I know a lot of the agents are barely getting in the trenches and coming back. I know next week is going to be full blown again, where agents' mindsets, motivation, and everything. So again, I definitely appreciate you jumping on today's contract class. We're going to go over the California Consumer Privacy Act, okay? And the importance as real estate professionals that we are. What is this? What does this entail? And what do we need to know about this new restrictions, okay? Now, this was enacted back in 2020, okay? So it's not something new, but I also want to emphasize the importance of how we protect consumers in the proper documentation that we need in order for us to be in compliance, okay? So let's go ahead and get started. So what is this new California Consumer Privacy Act? Well, it gives California consumers the right in their own personal private information that certain companies collect and use in the course of business. So think about that for a quick minute, okay? Can you do me a favor? Just slide the glass door so that we have a little bit of privacy and don't interfere with the flow of the office. Thank you so much. So the whole purpose of today is really to understand the elements, right? Because we as real estate professionals, we gather information, personal information. Think about what that is. What is it that you collect from the consumer? Yeah, a lot of information, right? What is some of the stuff that we collect?
Social Security,
Okay, so
bank account,
yeah,
bank information.
absolutely. Yeah, sometimes we collect on applications for leases, right? We have them send a application, and on the application, Social Security information, or when you're back and forth with a lender, right? The lender is probably asking for certain documentation from the consumer, right? So in essence, these are all part of what we need to know and how to protect the consumer, and what is the right way and how do we navigate it if the consumer says, please take me off. Okay, and that's what we're going to be diving in today. Again, this was in effect as of January 1st, 2020. Okay, so this was almost 5 years ago, right? That this came into play. But I think as real estate professionals, we have to be mindful and understand the elements when someone is saying, please remove this, from your database, and we have to respectfully do so. Okay. So what does the CCPA protect, right? Personal information defined as any data that could reasonably be associated or linked with a household or consumer. Broadly includes name, okay, addresses, as you were saying, right? Emails, Social Security, numbers, bank details, employment, details of IP addresses, purchasing history, and any inference drawn from any information to create a consumer profile. Okay, so you want to start thinking, folks, on what that looks like, right? What do we collect, right? Emails, personal information, phone numbers, right? Date of birth, how many, if they're significant others, husband and wives, right? Partnerships, children. All of that you have to take into consideration, especially, right, when we're inputting information on the MLS. How many times have you had a consumer, after you have successfully helped them close their home, right, and you were representing the seller, and now the buyer's agent is reaching out, hey, I want all of those photos removed, right? Because once we close it, any and all photos will be in the internet, right? And sometimes the new buyer may not want any of that information being publicized in third-party websites, right? So these are some of the elements that we have to take into consideration. Now, based on CRMLS, right, you can only have one photo, and that one photo should be of the exterior of the home. But any internal photos, you have to put that as part of the request, or ultimately before you close it, I would say remove it from the MLS. Okay, remove all of the photos from the MLS. That way, it only complies to the rules and regulations of the MLS to have one exterior photo. And sometimes that will eliminate any future issues or complaints coming back from the consumer or the buyer who bought that place saying, hey, I want all those photos removed, you know, from the internet, right? So we have to be in compliance with something like that, as an example. Yes?
Do you do this automatically or you wait until they ask you to do that?
Well, it's not typically automatically, right? It's only, it's part of the request.
Okay.
Right?
Yeah.
But I want to be mindful is that if I'm the listing agent, right, our number one priority is close the deal, right? And close it, so that way we get the full credit of it, right? And usually if there's another buyer involved, as an example, they're also going to get the credit for closing that deal. Let's just say as an example, you're the listing agent, you input it on the MLS on a property for $1 million, and now you have an agent who represented the buyer. And now we're going through the motions of closing the deal. We finally get reporting, right? And now we can officially close it on the MLS. Then we go into the MLS and we now officially close it, right? And it's going to ask for certain stuff before we actually finalize it. Part of the segue is we got to be mindful, like the photos as an example, right? Maybe there are some photos in there that the new buyer may not want to be publicized, you know, because once it's publicized, you know, it's really hard to control that. But you can try to at least eliminate some of the concerns by removing all, because sometimes listing agents put 50, 60 images, you know, of the property, and you have consumers out there that are very private and do not want to have those out in the internet.
Would it just be a good practice to just make it part of your thing to do it every time, just take the photos up?
Yeah, that's something that you can have as a checklist, as a reminder, you know, all of the do's that you need to do, right? I have to do this, I have to do that, I have to do this. And part of it maybe is just to eliminate all of the photos, right? Because those are your photos, you paid for them in most cases, right? So you can remove them from the MLS. But that's just one tip of the iceberg. There's other stuff that you also have to be mindful as well. Okay, so any questions so far regarding this slide? So personal data. What type of records does the CCPA protect, right? Well, CCPA does not distinguish between electronic records and other forms of records. So even paper files fall under the CCPA protection. Okay, so we have to, as consumers, understand and be able to, you know, protect them, right? And how we protect them is, you know, all of this information, we're not just going to divulge to everyone, right? We have a system in place, right? Because one, the Department of Real Estate tells us that we need to keep records up to what? 3 years, right? So we have to maintain a file for 3 years. Now, the cool thing, and it's pros and cons, the cool thing is that Keller Williams in its database retains files up to 7 years.
Right.
Yeah, after more than, you know, after 7 years, then we can discard it or remove it from the system. But part of the Department of Real Estate, they only emphasize that it only has to be 3 years and we can discard the file. All right, so I hope that kind of clears that. Who does CCPA protect? Any natural person who resides in California. Okay, so what does that mean? Anyone that resides in the state of California, they're protected under this rural consumer protection. Okay, so natural person, does that mean someone that passed away? No, right? It's someone that's still alive, right? Does that mean pets and animals? No. It says natural persons. Okay, so just want to be clear and what that protection is. So if someone calls and said, hey, I don't want my dog's name to be on the internet. Okay, well, that doesn't protect the dog, unfortunately, right? And I'm being funny about it, but you get the point. You get the logistics on it, right? So any natural person residing in the state of California. All right, who must comply with the CCPA? For profit legal entities, including sole proprietorship, who do business in California. Do we do business in California? Yeah, absolutely. So you also fall under this as part of the process, and sometimes part of the problem as well. Collecting personal information, okay? Collecting personal information directly or through others, such as salesperson or on behalf of the broker, right? You're under the umbrella of Keller Williams, right? And we collect a lot of data for many reasons, right? We have title companies, we have escrow companies, we have third-party home inspection companies, and all of them have their own database that they collect information, right? Well, they also fall under this platform that they must comply with the CCPA in the consumer protection if someone files a complaint. Also determines what to do with the information and how it's used, okay? So again, anyone that does business in California collects personal information directly through others, right? Or determines what to do with the information and how it's used, right? So think about it for one quick minute, right? A lot of the information that we use is what, like CRMLS, like the MLS. We have third-party platforms, right? Like Zillow. We also have our client relations tool, right? Which is Command. We have smartphones, we have computers, right? There's a lot of information that is part of it. And because you're a real estate professional licensed in the state of California, we have to comply with certain rules and regulations. Now, this is not a common thing that you're going to see constantly people complain, but you want to be mindful also, folks, you want to be mindful that the protection that you must endure to is to protect the consumer if they are wishing to have their privacy protected. And we have to do the necessary steps in order to comply with that, because as soon as they file with the state of California, then an internal investigation can happen. It's kind of similar to the do not call list, right? It's kind of similar to the do not call list, right? This is, again, just personal information. And we talked about what is that personal information? Name, date of birth, social security, right? Addresses, significant others, partnerships, right? Anything and everything that would be considered private is now protected under the umbrella in the state of California, okay? And as real estate professionals that we are, we have to be, again, really mindful and sensitive to someone's concern. To us, it may not be a big deal because that's who we are. We're constantly getting information, right? As soon as we jump on the MLS, we go right into Realist. We know who the owner of the property is, and then we have third-party sites that will either give us like social platforms, right? Like Instagram, Facebook, right? Or LinkedIn, right? And see if we can kind of connect the dots. Again, if someone files a complaint, we have to be able to maneuver that and remove it from the system. Okay. All right, so compliance requires only if the entity meets one of the following, okay? So has 25 million or more in annual revenue, derives at least half its revenue from the sale of consumer personal information, and it annually buys, sells, or otherwise shares personal information of 50,000 or more consumer households or devices, okay? Maybe you as a personal may not, but the company does. And because you're under the umbrella of a brokerage that does fit all of these three platforms, that means we have to be in compliance with it. So if you get someone complaining, you need to, handle it or take care of it or relate it to the leadership team, and then we can help, basically resolve the issue. Okay. So what does a cover business have to do? All right. So here's part of the process. Okay, please write this down. Write notes. Take a photo of this because this is again how you're going to be in compliance. Give consumer a notice. All right. Before you say anything, people on Zoom, please. Where do I get this notice? Okay, it's part of our zip forms, and I'll explain it shortly. Okay. So that's going to be the first thing. And I'm surprised no one in the in class said, hey, where do we get this notice, right? Well, zip form has created a form to divulge and disclose, and it also provides information where the consumer can now direct right through the website if they want to file a complaint or update any information. And I'll share with that information shortly. Respond to a consumer. Allow the consumer the right to opt out. Delete the consumer's personal information upon request, except if it's legally obligated to maintain. Brokers are obligated to maintain records for what?
3 years.
Yeah. Okay. So 3 years. That's part of the Department of Real Estate. So we're protected under that umbrella. And if it gets sideways for you, you direct it to the broker or leadership and let leadership handle that consumer if they're asking for any of this stuff to be removed. Then we as leadership can dive into the conversation. Unfortunately, under this protection, we have the right to retain this file for up to 3 years. Okay. Now, as I stated earlier, right, Keller Williams retains files for 7 years. Okay, 7 years. So, but under the Department of Real Estate, it's only 3 years. MLS is required to keep the listing for 3 years as well. 3 years. I think it's longer with CRMLS, but I can be wrong as well. Okay. Any questions regarding this slide? Okay. So here it is. The obligations for non-covered business under the CCPA, folks, must still provide consumers a notice that information is shared. Must provide consumer notice of right to opt out from a covered business. A non-covered business does not have to contact the covered business on behalf of the consumer. The form is the CCPA, satisfy the notice of obligation. Okay. Now, guess what? This form populates already, and it has been populating since 2020 through your zip forms. As soon as you do a listing, and I believe it's as long also when you do a purchase agreement, this is part of your advisories and disclosures, right? Similar to the agency disclosure, the possible representation of one or more buyers, right? The Consumer Privacy Act advisory is part of that package that includes that the buyer, the seller, the landlord, or the tenant will sign as well. Okay. And again, you don't have to worry where you need to get this notice. Anytime you're doing any type of real estate activities with a consumer, buyer, seller, investor, right? Developer, landlord, or tenant, this form should be included as part of the process.
Persona.
Question? Is there a question on Zoom?
Is it only for money?
I'm sorry, what?
It's for making money?
It's for making money? No.
Personal information, they are going to sell it to the other people.
Well, not necessarily, yes and no. I mean, the information that we gather, right, is usually sold in a third party, right? And this is like monthly subscriptions that we do, right? Similar to like paying your MLS, right? We have access to data, which is personal information, right? You know, as soon as you have access to the MLS, right, you can now do CMAs, you can do a lot of information, right? You can also check for off-market information of a particular property, right? Well, we pay for that service, right? So to answer your question, 100%, yeah. Sometimes it's for that purpose that we're buying and people are gathering this information to sell to us who need it to do our job. Yeah, so, yeah, it's pretty spot on that. Okay. So what are the penalties for non-compliance? All right, so there's a civil fine of up to 2,500 and up to 7,500 for intentional violation, right? Potential exposure for $100 to $750 per consumer incident if data is breach of a non-encrypted information. Okay, most, if not all, of the information is encrypted. Meaning like when you jump on the MLS, right, you have to go through hurdles, right? You got to put in your username, your password. It's not something that someone can just take your information, right, and ultimately use it for their advantages or benefit, right? They have to know your information, your login, your password, and all that fun stuff, right? But that's what it imposes if it's breach, right? Now, we have no control over third-party sites, right? Like CRMLS is an example. Like Command, if it's an internal breach, right, it impacts all of the Command platforms or CRMLS, then that's beyond us, then they'll probably end up suing, the bigger companies as a platform. But this kind of gives you an example. All right.
So when there is a breach happen, it's going to be put a penalty, right?
Yeah. If it's a big, huge breach, then it usually will be the company that created the platform. Like, let's just say, haven't you guys all got notices when someone sends an email saying, hey, Best Buy was breached, and they'll provide you with free credit check to make sure that your information is not compromised, right? And they'll give you like a 1-year subscription to monitor your credit reports, right? Well, that's kind of a breach that they will do because they're trying to offset anyone compromising personal information, right? Because what can they do with personal information? If you have their name, you have their address, you have their phone numbers, you have their emails, and sometimes we have social securities. What's to say that someone in the black market will use that to, open up accounts, right? And we have a lot of sensitive information. So we have to be mindful, folks, in how we navigate the personal information, because again, things are being sent back and forth, right? DocuSigns, right? Emails, right? Text messages, voice messages would sometimes may fall under that platform as well. And just be, again, mindful of some of the concerns that may come up. Now, it's very rare that it happens to us, but again, this was something that was enacted back in 2020 as reinforcement that we have to now put that as part of our disclosures. And that's where this form was created right here. Okay. The California Consumer Privacy Act. And it says, I'll read it to you. As of January 1st, 2020, the California Consumer Privacy Act commends with the Civil Code Section 1798 CCPA grants to California residents certain rights in their private personal information that is collected for companies with whom they do business under the CCPA. Personal information is defined broadly to encompass non-public records, information that could reasonably be linked directly or indirectly to you, including potential photographies of a sale information, right? How many times, again, on the MLS, we take information, right? And not all properties are vacant, right? Some of the properties we're selling with personal stuff in there, right? And the consumer may say, look, I don't want that to be seen, right? Especially utilizing common sense, right? Here's an example. There's a safe in one of the closets, right? Do you really want the photographer to take a photo of the safe? Absolutely not, right? Because that's a target. Because once it hits the MLS, now that information is exposed, right? That they'll know they can tie the address, right? And know the location of where that safe is, and now, break-ins, okay? Just yesterday here in the city of Torrance, I don't know if you've heard, but at the Morgan jeweler on Hawthorne and Sepulveda, the Torrance SWAT, the helicopters, police with their guns drawn were in the building, in the facility. So I immediately thought there was probably a robbery happening. But ultimately, there was a mental case individual who went inside, looked very suspicious, left, came back, and all that stuff. So they ended up calling the police. Nothing serious, but you just never know, right? These incidents have happened. So something like that, just think of the little things and be mindful, right? When having the conversations with your clients, right? When you're sitting down and going through the listing presentations, the initial plan of action, right? What are we going to do? Part of it is taking photography. So if there's something that you don't want the photographer to take, please let us know, so that way we do not put it on the MLS, because once it's on the MLS, it's going to be very hard. We can remove it, but it's uncertain, and it's not 100% that once it hits, the MLS and, the internet, nothing is secure, basically. So this is the reason that they put this in place. Some of your personal information will be collected and likely shared with others during the process of buying and selling real estate. Depending on the situation, you may have the right to opt out or stop the transfer of your personal information to others, and request that certain business delete your personal information altogether. Not all businesses you interact with are required to comply with the law, primarily those who meet the criteria of a covered business as set forth in the section 1798. For more information, you may ask your broker for a copy of the CAR legal questions on the subject, and I'll provide you where you can get the Q&A. Again, all of this information is straight out from the California Association of Realtors. Okay. The real estate broker is likely to submit personal information to the MLS listing service, MLS, in order to help find a buyer for a seller property. Through the MLS, the information is made available to real estate brokers and salesperson, and those even after a sale is completed, the MLS distributes sales information to the real estate community. Broker agents and MLS may also share personal information with others who post the personal information as websites or anywhere else or elsewhere, or otherwise use it. Thus, there are various service providers and companies in a real estate transaction who may be engaged in using or sharing the data information of your personal stuff, right? So again, it's a full disclaimer, full disclosure on what this form, and as real estate professionals, what we gather is ultimately can be potentially exposed, right? But at the same token, as the consumer is protected, we are also protected under this advisory, is that we're providing this as a disclosure for the buyer, the seller, to sign off on it, okay? And then lastly, most MLS will not be considered a covered business. Instead, the MLS may be considered a third party in the event a covered business. Example is a brokerage, real estate listing aggregations, advertisement, internet sites, or other outlines who meet the criteria of covered business exchange personal information with the MLS. You do not have the right under the CCPA to require a third party to delete your personal information. And like real estate brokerages, even in the MLS is a covered business, MLS are also required by law to retain and make accessible in its computer system any and all listings and other information for 3 years. So that's the requirement. Okay. So let me do this real quick. Additional information, you can get it right off via Q&A, the California Consumer Act, by clicking here. I'll just show you where you can get this information. People on Zoom, can you still see, this information?
Yes.
Yeah,
All right, so here is the California Consumer Privacy Act. And again, it just reinforces exactly what we were just talking about. Also, if you wanted to go to CRMLS, log into your account. Hope for the best. Okay. So when you jump on CRMLS, something is happening here and it's not logging in. Let's go back here. And let's jump onto your transaction as an example for the access. Validate. Form update, the cell phone has been discontinued and now you utilize the MLSA, has all the instructions that were previously on the cell phone and can be used in its place. Oh, good to know, right? All right, so let's just go again and let's open up a purchase agreement and see if it validates and also provides that form. All right, so here's a purchase offer as an example. You have your residential purchase agreement, but let's see if it does or if we have to include it. We're going to go all the way to the bottom. So you've got your buyer investigation advisory, possible representation agreement of more than one buyer and one seller, fair housing advisory, home buyers insurance advisory, all these different advisories. Wire fraud, okay, that's something that we, don't see as often, but about 7, 8 years ago, it was really a big thing. And here it is, the California Consumer Privacy Act Advisory Disclosure. So you don't have to worry, it's already packaged with all of the additional. So it's not just the purchase agreement, you've got the possible, the wire, the agency disclosure, the California Consumer Privacy Act. All right, and both the buyers, sellers, landlords, and tenants would sign off on this, okay, if you represent any of the clients. Now, the consumer also can go to the privacy CPA. So let's just say, we go here and just type in CCPA. Now the consumer.
Hey, Simon,
Yes,
I don't think your screen that you're showing over there is showing on Zoom.
it's not, okay.
Yeah.
Okay, thanks. It's definitely showing on my end over here, so. Let's go back. Hopefully this works now. Can you see it now?
Yeah, there you go. Thanks.
So again, the consumer can go to the California Consumer Privacy Act, CCPA, click here. And there's a lot of information on here as well. There was another platform that's, opting out. Here is if, again, if they have any additional information regarding the CCP, Consumer Privacy Act. You know, it gives the consumer a little bit of information of what that is. Also, if the consumer wants to file a complaint, they can also file a complaint directly with CCPA. There is a site that they can go in there and file a complaint against an organization or an individual if they feel that they've been their information has been compromised, as an example. Okay, so that pretty much concludes our class today. Any questions regarding this? It's pretty much more of an educational conversation. It's not something that you're going to probably hear anyone really say anything. The majority of complaints that I get is really the MLS and removing photos. That's really what I get the most, right? Is can you, please remove all of the photos from the MLS. And the only way you can do that is prior to closing. So if you are the listing agent, you want to do it before you close it out, is go into your portal and then ultimately delete all of the photos, right? You still have to have one photo to be in compliance with CRMLS, but it has to be one exterior photo of the property. And then you can officially close it. So when it now shows as a closed deal, when the consumer or agent see all of it for comm purposes, they're only going to be able to see one photo instead of 50 to 70 images. That's one way of doing it. Let's say that you do close with the 50, 70 images, then you would have to put a request to CRMLS. You've got to also let the broker know, and the broker will have to call CRMLS compliance and request to have the images removed, because I don't even have the authority after it closes to remove images on the MLS. Okay. Now, if you're the buyer who represented if you're the agent representing the buyer and the buyer's requesting it, then you want to immediately call the listing agent, tell them, hey, we run this transaction about a month ago, 2 months ago. My client is requesting that all of the photos be removed as, as a courtesy. Is it possible to have you and CRMLS remove those images from the photo? Most listing agents are not going to have a problem with it. They'll do it, as a courtesy. But again, these are some of the complaints that we see as an office. Not much, personal information, but more like the do not call list, right? We get tons of calls on the do not call list. Hey, I don't understand why you have my information. I'm a register on the do not call list. I want you to remove me from the list, right? And the common sense, common courtesy as an agent who is reaching out and calling is to respect that, right? Because hopefully, most third-party companies that provide you with phone numbers, they should scrub and make sure that it is in compliance with the do not call list, right? But sometimes they fall off the crack, and unfortunately, someone will say, hey, that you're calling me on a phone number that is part of the do not call, please take me off. So as an agent, you just got to follow the procedure, and that procedure is, if you look at your policy and procedure manual, it clearly says the procedure and protocol that you must follow when someone says, hey, please take me off your list, right? You got to immediately let the office know, let us know the phone number that the complaint came in, and that way we can now share that information to all of the agents to say, hey, to be in compliance, we got this information, we provided it to all of the agents, not to call the specific number. And then that puts us in a position of compliance. Okay. Right, team. Well, that pretty much concludes. If there is any other questions, thoughts, you can always reach out. If not, then I'll see all of you on the next contract class. Thanks, everyone. Thanks, everyone on Zoom.
Thank you.
Thank you.
Thanks, Simon. Bye-bye.
Thank you.